Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. And tonight we are going to cover Chapter 6, which will include attempts, solicitation, obstructing justice, and conspiracy. Just a quick reminder again, don't forget about those cool things at the end of each one of the chapters, the terminology and definitions, the true or false questions, the short essay questions, and then the terminology matching quiz. Those things, again, are excellent resources for you to help you study for both the weekly quizzes and, of course, your chapter exams. So as we jump into Chapter 6, and again, we're talking about attempts, solicitation, obstructing justice, and conspiracy. We're going to start off with attempt. And we've already gone through a lot of information that talks about what a crime is. And we've even talked about the elements of crimes and things like that. So what about those crimes or those things that happen where they're actually not completed? So that's where this attempt comes in. So the best way, of course, to kind of get things rolling would be to define attempt. What is it? Well, it's found under Penal Code 664, and an attempt to commit a crime is in fact a crime itself. And you're saying, like, really? So if you look at the definition, an attempt to commit a crime is a crime in itself. Every person who attempts to commit any crime but fails or is prevented or intercepted in the perpetration thereof, meaning carrying out thereof, is guilty of an attempt to commit a crime. So, wow, so you can actually be held responsible for an attempt to commit a crime. Now, there are some elements that have to come along when you're talking about an attempt, and there are basically two, and these are found under Penal Code Section 21, subsection A. And the two elements that form intent here, that form attempt are A specific intent to commit the target crime. Now remember, we talked about intent, I think, in the last lecture, where we know there's general intent and specific intent, and we know specific intent is different. Does everybody remember? So that's where you have that requisite mindset to carry out whatever it is that you're going to do. That mens rea, if you remember. So again, the first thing, specific intent to commit the target crime, whatever that is, and a direct but ineffectual act towards the commission of that crime. Well, what does that mean? What does act actually mean? Well, when we're going to define act, and remember, when you're looking at law, and that's what we're looking at here, a lot of these things are all defined for you. So you can find the definition of words, not just by looking it up in the dictionary, but you can look in various areas, including case laws, that define different things. And here we're going to look at what act is, because we just got done hearing, hey, a direct but ineffectual act toward the commission of the crime. Well, what would that act be? How much of that act has to happen to define attempt? Well, the act must come what they call dangerously close to completion of the crime. As a matter of fact, it must come close enough so that the crime apparently would have been completed, except for that little part about being interrupted by some circumstance not intended in the original plan. So how about an example of somebody maybe walking up to the window of a residence, and going up to the window, and their intent is to pry that window open and break in and steal your TV, your cool big screen TV that you just bought. And they pull out the screwdriver, and just as they're going to stick that screwdriver underneath the screen, they haven't done it yet, the neighbor walks around the corner and sees you, and you don't want to be arrested or questioned or anything else, so you just kind of turn and walk away or something like that. So I know that might be kind of a corny example, but honestly, that's a good one. The crime of burglary there didn't actually happen, but Do you think in your mind that the act that the person did came dangerously close to completion? As a matter of fact, it came so close that that crime of burglary probably would have been completed except for the neighbor interrupting. And that's where that attempt comes in. So it's also known, again, and these are in the definition areas that you can look at, as what they call an inchoate crime, meaning incomplete. So it's an incomplete criminal offense. And we've already just heard some examples on the fact the act must come dangerously close to the completion of the crime. Well, what about the punishment? So if you can get arrested for attempt, and you really didn't do the actual crime you set out to do, but you came dangerously close, and you fell underneath those elements of Penal Code Section 21A, those two elements, and you get arrested, let's say, what would the punishment be? Well, here's kind of an interesting thing, and I really don't know how it ended up like this, but I guess it's fair. The punishment is usually half of the completed offense. So let's just say, for an example, burglary is 3, 6, or 9 years. Now, I don't think that's it, so don't hold me to it, but I believe it's actually a little bit less. But just for this example, it makes it simple because we're going to go in like years of 3 or whatever. So 3, 6, or 9. If you're convicted at the highest level, it could be 9. But for attempt, it would only be half. So 50%, meaning like it didn't really happen. You only got half done. So interesting. Just kind of thought I'd throw that out there when you kind of look at how these things come about. Now, punishment, if you want to research it further, for attempts can be found under Penal Code 664, and it talks about punishment for an attempt is usually half of the sentence, state prison or county jail or fine of the target crime. Now, there are some exceptions to this, and exceptions are things like attempted murder, which can be punished by life in prison, of course, with the possibility of parole, and attempted, say, premeditated murder of a police officer, punished by a minimum of 15 years to life sentence. So there are a couple of exceptions that are built in there. Well, how about those crimes that might be divided by, let's say, degrees? So we know that we'll look at burglary again because it's kind of an easy one to go with. So burglary has first degree and second degree, and we'll learn more about that in some chapters coming up. And one is a little different than the other, and the penalty for one is going to be more severe than the other. Well, those crimes that are divided into degrees, they have a section for that. Now remember, we're talking criminal law. There's a section of case law or something for anything. So under 664 subsection D, it talks about if a crime is divided into degrees, an attempt to commit the crime may be of any such degree, and the punishment for such an attempt shall be determined as provided by this section. Now, I know it's kind of a little bit of legalese, but there you have it. So a little bit of review for us, because that's always good before we move on. The elements of attempt. We know what attempt is. So the elements, again, specific intent. So you have to have that requisite intent to do the target crime. A direct but ineffectual act towards the commission of that crime. Remember, attempt crimes are specific intent crimes. They all are. Mere agreement to commit a crime does not constitute attempt unless there is some overt criminal act which comes close to the crime. And finally, mere preparation really isn't enough. So just preparing for something like that really is not enough. Now, before we kind of move on, I'm going to talk a little bit about attempts, commission of different crimes under Penal Code 665, and then we're going to do a little quick review right here. So what about an attempt to commit, say, burglary, but during that burglary you commit a different crime? You actually carry out another crime. And could that even happen? Well, I think it can on certain types of crimes. And this, again, there's a section that kind of covers that. So it's Penal Code 665, and it says, this section provides that a person who, in attempting unsuccessfully to commit one crime, accomplishes the commission of another different crime whether more or less serious, is guilty of the crime committed. Okay, so that kind of makes sense. In such cases, the suspect could be tried for both the crime and the attempted crime committed. For example, okay, if in attempting unsuccessfully to snatch a purse, a suspect injures the victim, the suspect could be tried for both attempted grand theft person and for battery, right? So see how that makes sense? So interesting fact when you're talking about law, and these are great examples, you can see how you really have to read stuff and kind of dig down in there and look at the sections and look at the wording and understand that there are just so many different things that could take place. Like I'm attempting to do this crime, but I do another one. So can I be held responsible for both? Or am I just held responsible for just the one that's higher, or the one that I actually did, not the one that I didn't do? And this section 665 clears that up for us. So again, kind of a quick review here before we move on. Attempt defined. Most attempt crimes are noted with the Penal Code 664 before the crime. So this is usually how attempted crimes are identified. So they'll have like 664, the example we have here, /187 equals attempted murder, or 664/459 attempted burglary. And that's typically how an attempt crime would be written. Now, in some cases, however, an attempt crime is declared by a very specific penal code section all by itself. And this is sometimes done to allow state legislators some flexibility in designing the attempt element criteria. But again, there are times that it will have its own section, and the example that we have for you here would be Penal Code section 455, attempted arson. So the actual arson section is Penal Code 451, and then there's a bunch of subsections underneath it relative to different aspects of arson and what have you. But they've got a entire attempt section here, so there's no need to put the 664/451. They're just going to go right to the actual definitive section. Hey, attempted arson is Penal Code section 455. So I hope that kind of makes a little bit of sense as we kind of move on. Now, I want to give you a couple other examples of attempt, which I think are interesting, and we don't have to look at the case laws that go with them, but I thought it would be good for you to hear these. So entering a car without the owner's permission and operating or manipulating the starter in an apparent effort to start the motor, that would actually qualify as an attempt car theft. Other examples would be, let's say, sawing a lock on a warehouse door, starting to remove the screen from a house window, piling lawn furniture against a backyard fence for pickup by an accomplice parked in the alley. Okay, those are other examples of attempt. So cutting off the lock, I mean, that one kind of makes sense. Maybe you're scared away after you cut the lock off. Well, you didn't get in, but you sure did make that overt act towards the commission of the crime that was extremely close before you were scared off, or whatever the situation was. A couple of other interesting kind of things that we'll talk about really quick. It's been held that firing multiple shots at a car with multiple occupants constitutes a separate count of attempted murder as to every occupant, because they're all in what they call the zone of harm. Now, that case is People versus Trujillo. It's a California case. You don't really have to look it up, but the thought here is, that because these group of folks are all together so close in that zone of harm, if someone were to shoot into that occupied vehicle, then each one of those persons could easily have been a victim. And there definitely was an overt act towards the commission of the possibility of a murder, right? So that's kind of how that one plays out. So again, some interesting stuff. However, here's a different slant on it, and you kind of think about this one. Firing a single shot at a crowd of people is only one count of attempted murder. So several shots into a car where all these people are like, kind of stuffed in there would be a separate count of attempted murder on each one, but firing one shot into a crowd of people is one count of attempted murder. So, there you have it. Just a couple of different things that we can kind of look at. Well, so now we're going to look at abandonment. So let's say that we decide, what, we've got a change of heart and maybe we don't want to commit this crime. And we decide, hey, we're going to abandon basically doing it. So can we not be charged with attempt if we're going to abandon our actual move towards the commission of a crime or something like that? So when a defendant commits acts toward the commission of a crime, that satisfies that, there's that word, corpus delicti, of the crime of attempt. So when you make that act towards the commission of a crime, and those other elements come into play, like being dangerously close, etc., that satisfies that corpus delicti of the crime of attempt. However, a defendant may use the criminal defense of abandonment if a couple of things happen, and it's kind of an interesting thing. So if the person freely and voluntarily abandons the act of committing the crime, okay, and notice it says and, it doesn't say or. So two things: freely and voluntarily abandons the act of committing the crime and is not in final execution of the crime or dangerously close to committing the crime. So basically it has to happen. You got to give yourself some space in there. You can't be dangerously close to committing the crime. So assume, for example, that a suspect specifically intends to commit a certain crime but is interrupted during the crime. Assume also that had he not been interrupted, he would have completed the crime. Well, this person cannot rely on that interruption to kind of negate his criminal acts. Okay, he is in effect guilty of the attempt, because when we go back up to what we just read, commits an act towards the commission. So you can't use the fact that someone scared you off or something else as an excuse or a defense. Abandonment is a defense only if the attempt to commit a crime is freely and voluntarily abandoned before the act is in the process of final execution and when there is no outside cause prompting such abandonment. So that kind of narrows it down a little bit more, actually. No outside cause, like the sound of a siren driving down the street, or the neighbor looking over the fence. Okay, you can't use those as excuses. You have to have actually abandoned the thought of you doing that crime. So I hope that really kind of clears it up, and I think we did a pretty good job of making sure that you have a good understanding of what that is. Well, along with that, there are a couple of other legal things that come into play, like the possibility of completion or even the impossibility of completion. So if you're in such a way that you actually couldn't complete this crime, is it still a crime? Well, let's talk about that. So we'll start with the possibility of completion. There can be no crime of attempt if there is an impossibility of its completion. So what does that really mean? Well, there are those cases where it would appear that the defendant was in a physical position to commit a crime, but was unable to complete the act because of a legal ramification or technicality. So an example here could be, let's say someone throws red pepper in the eyes of another with the intent to blind him. Now that would be Penal Code 203, which is mayhem. And it can be shown that the material thrown was not pepper, and would not destroy the eye or eyesight. Well, then the suspect can't be guilty of attempted mayhem. Now, they could be guilty of assault or battery or some other charges. So, in order to determine whether a crime is apparently possible to commit, it is necessary to kind of look at other court decisions. And those cases can actually help us kind of figure it out. So an example here, again, a defendant cannot be guilty of theft when he or she attempts to steal money from an empty cash register. But, okay, so here's the law part again. It's kind of weird, but just bear with me. They can be guilty of attempted theft. Does that make sense? So the attempted theft, remember, specific intent to reach in and steal money out of the cash register. Now, if they completed it, it would actually be it wouldn't be an attempt, it would be the actual crime itself. But remember, attempt is a crime in itself also. So here the scenario that we're giving you is that if this person attempts to steal money from an empty cash register, they reach in and there's nothing there, they can't satisfy the actual crime of theft, but they can be guilty of attempted theft. How cool. So there's just a couple of interesting examples on when we talk about the possibility of completion. So let's look at a couple of different ones and see if we have some other things we can bring forward. So in order to determine whether a crime apparently possible to commit or absolutely impossible to commit, it is necessary to look at court decisions. As previously said, if the crime can apparently be consummated, then it can be attempted. Cases have held that the defendant's lack of knowledge of the impossibility of carrying out his or her intention is really immaterial. So remember the example I just gave you. A defendant could be found guilty of attempting to steal money from an empty cash register or from the person of another, like a pickpocket, who has no money in his pockets. So kind of an interesting set of circumstances. Well, what about the impossibility of completion? Well, I mean, because we've looked at the possibility, what about impossibility? Well, physical or factual impossibility of completing the crime is not a defense unless the conditions were known in advance to the suspect. So an example there would be if a pickpocket reaches into a victim's pocket but finds it empty, he is guilty of attempted grand theft from a person. If an assailant shoots at a cashier in a glass booth, not knowing that the glass is bulletproof, okay, he is guilty of assault with a deadly weapon. Legal impossibility, on the other hand, is a defense. For example, trying to kill a person who is known to be dead cannot legally constitute attempted murder. So kind of a little review. I know it's a little bit legalese-ish. So legal impossibility is a traditional common law defense to a charge of an attempted crime. You have to kind of think about it. If somebody attempts to do something, the defense is probably going to be, hey, he couldn't have done it. He couldn't have carried it out anyway. So that kind of makes sense when you look at it that way. Physical or factual impossibility of completing the crime is not a defense, okay, unless the person knew those conditions in advance, and typically they don't. Now, legal impossibility, on the other hand, is a valid defense because, again, the example that we're using here, trying to kill a person who is known to be dead, cannot legally constitute attempted murder. Now, it might constitute some other crime, but it's definitely not going to be able to constitute attempted murder. So we're going to kind of move in. We're going to take a little move from attempt and talk a little bit about solicitation and what that really means, and then go into things like bribery and oath of office and things like that. So solicitation to commit a crime. Well, Penal Code 653F says every person who, and again, these are one of those sections that you have to read. So you want to be able to read these words and understand what the section really means. So every person who, with intent that the crime be committed, solicits another to. Now think about that. Every person who, with intent that the crime be committed, solicits another to offer or accept a bribe, commit a robbery or burglary, commit grand theft or perjury, or something similar, is guilty of a felony. And county jail time, 16 months, 2 years, or 3 years. And to ask a person to commit or join in itself completes the crime of solicitation. There's really no overt act toward the crime that needs to be done. And there's a case that you can kind of look up if you want to dig a little deeper on that. It's People versus Burt, and it is a California case. And there really also has to be, for the crime of solicitation, it must be proved with or by cooperation. So these are the facts that have to be present in order to formulate or reach that crime level of solicitation. Well, what about, and it didn't have it in here, so I'm sorry, I was looking for a specific slide, so I'm going to back up, and I don't see it here, and I probably should have put it in there, but it's not in there. So one thing that's kind of an interesting section, and it still falls under the solicitation to commit a crime or the solicitation section, so that's kind of why I'm going to stay here for a second, would be soliciting street gang members. So this section is Penal Code 186.26, and it basically says any person who solicits another to join a gang, okay, now you have to read it, with the intent that the person solicited will participate in felonious gang activities, is guilty of a felony. And this is actually a pretty cool section. Threatening or using violence to recruit or coerce another to join the gang results in an additional 3 years imprisonment, consecutive to the term imposed for the solicitation itself. So now we've got some law, some good legislation on soliciting gang members and what have you. So an interesting section, 186.26. Well, how about maybe where we have say one crime and maybe we're going to compound that crime, is kind of what they call it. So let's look at something called, we probably know what obstructing justice means, but let's look at compounding crimes. So where a person who has knowledge of the actual commission of a crime agrees for a fee to compound or conceal such a crime, or to abstain from any prosecution thereof, is guilty of violating that section. Now, the administration of justice may be obstructed in many different ways, and for the purposes of the sections that we're talking about, we're gonna limit these to 5 different things, and we're going to go through each one of these pieces individual. We're going to we'll review here in a second compounding crimes. We'll look at perjury. We'll look at something called subordination of perjury. We'll look at bribery and falsification of evidence. And these are just the 5 things. There's more, but we're going to limit these to the 5 things that fall under obstructing justice. So compounding crimes, again, where a person has knowledge of the actual commission of a crime, agrees for a fee to compound or conceal such a crime, or to abstain from any prosecution thereof, is in fact guilty of violating this section. So the next one will be perjury, and let's take a quick peek at perjury. And you've probably all seen this on the news, and one of the more, what would we say, larger cases, or one of those cases that was really in the media where perjury came to the forefront, if you remember, would be the O.J. Simpson trial and the testimony of Detective Mark Fuhrman from the Los Angeles Police Department. And if you ever get a chance, it's really kind of an interesting thing that maybe you would want to watch some of the cross-examination of Detective Fuhrman, and you can find some of that on YouTube and some other video areas, or actually type into Google Mark Fuhrman takes the fifth, meaning that he doesn't want to incriminate himself. Okay, and you can watch part of his testimony when he actually decides that he doesn't want to make a statement under penalty of perjury. And we'll talk a little bit more, but that's a really great case to kind of look at. But let's look at perjury in itself and try to define it and apply it in a couple of different things. So perjury defined is found under section 118 subsection A, and it basically says every person who having taken an oath that he or she will testify, declare, depose, or certify truly before any competent tribunal, officer, or person in any of the cases in which the oath may by California law be administered, willfully and contrary to the oath, states as true any material matter which he or she knows to be false, and every person who testifies, declares, deposes, or certifies under penalty of perjury in any of the cases in which testimony, declarations, or certification is permitted by California law under penalty of perjury and willfully states as true any material which he or she knows to be false is guilty of perjury. So that's like the legal part. So let's kind of break it down here and look at it a little bit more simplistic. So knowingly making a false statement, either oral and written, or written. So anything that was written, anything that was videoed or whatever, or any oral testimony, okay? And a lot of times, again, remember, there are sections or cases that will define what oral means, and define what written means, and define what under oath means, or penalty of perjury. So this is the law, and this is the intriguing part about it, because you can actually read some of this and have a better understanding. This is the context part that I talk about all the time. So knowingly making a false statement, either oral or written, either under oath or under penalty of perjury. So if you've ever seen a witness go up to the witness stand, and you'll see the bailiff or somebody will tell them, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? And you say, yes, I do. You have just under oath said that, hey, you've sworn that to the court that you are going to tell the truth. So that's the under oath part. Under penalty of perjury could be something that you sign. Could be at a deposition where they'll tell you, hey, you need to tell the truth under penalty of perjury, or what have you. And again, there are some definitions in there that we can kind of look at. So we've got knowingly make a false statement, either oral or written. And we know that oral and written expands fairly broad. Under oath or penalty of perjury, we know what that is. With respect to a fact which is material, and we'll define what material is. You can kind of look down at the bottom here. Testimony is material if it could probably have influenced the trier of fact. That shouldn't be act, it should be fact. Not just when it in fact had an effect or influence. So if a star witness got up and lied on the witness stand, do you think that it could influence the trier of fact? And the trier of fact would be who? Those of you that have taken a class? That would be the jury. The jury is the trier of fact. The judge is the trier of law. And the trier of fact, those people, those 12 people, if it's in California, are going to decide things. And if somebody gets up and lies, could that influence them? Absolutely, it could. So that's why they have it kind of spelt out like this. So with respect to a fact that is material, meaning that it could influence somebody, before a competent legal tribunal proceeding or person, a court trial, a deposition, or something similar, you're guilty of perjury. And perjury is a felony punishable by imprisonment in the county jail for 2, 3, or 4 years. And it's Penal Code section, again, you'll find the definition of perjury under section 118A, and you'll find the punishment under Penal Code section 126. So those are the elements. Okay, knowingly making a false statement, oral or written, either under oath, penalty, or perjury, with respect to a fact which is material. Very important. We know what material is now. Okay, before a competent legal tribunal proceeding, etc. And then we have the punishment. Well, what about? So that's the person that just gets up and let's say lies or perjures themselves. But do you think you could actually ask somebody else to do that? And what have you. So let me, before we jump into this, I just something just came to mind. I want to make sure that we understand the importance of the under oath part really quick. So you can look up, again, remember I told you about words you can find the definition for? Well, you can define oath. It's Penal Code section 119. The term oath as used in Penal Code section 118 or 118A, that's perjury, includes an affirmation and every other mode authorized by law of attesting to the truth of what is stated. So that's you getting up there and swearing that you're going to tell the truth. And then oath of office, there's another Penal Code section 120 that talks about the oath of office administered to an elected official or appointed official, etc. Now that oath, okay, the reason they have you swear under penalty of perjury or take that oath is because if you lie, okay, you can be prosecuted for perjury. So, and it's not just testimony that's going to be given in an open courtroom. So understand this too. The Fourth Amendment talks about search and seizure, and it also talks about having to get a search warrant for certain things, or an arrest warrant to go arrest somebody, a search warrant to go search a place. And you do the same thing when you apply for a search warrant. You will go to the judge. You'll take your search warrant and all of its parts, and we're not going to go through all the parts right now, but you'll take that in there. The judge will read it, and at the very end of that, he's going to tell you to raise your right hand, and he's going to ask you something similar. Is all the information contained within this warrant true to the best of your knowledge, so help you God, or whatever it is that he says? And you're going to swear yes, and then he's going to sign it, they'll stamp it, you'll sign it, etc. Why do they have you do that? And hopefully you're kind of talking, talking to yourself in your brain or whatever, thinking, well, hey, that makes sense. Why would they have me swear under penalty of perjury? Oh, I get it. So in case I'm bad and I lie in this affidavit that supported this search warrant to go to somebody's house to take all their stuff, I could be held responsible for that. That's what I wanted to kind of get across. So sorry for the little rant there, but it just came to mind. But it is a very important piece about the oath part, about swearing under oath. So it's very applicable in a lot of different situations. Now back to where we were before, subordination of perjury. The crime of subordination of perjury has two essential elements. And we know what perjury is already, so we're good. So the first one, that one person shall willfully procure another person, procure, go get, another person to commit perjury, or to lie, okay, and that such other person shall commit perjury. So those are the elements. Every person who willfully procures another person to commit perjury is guilty of subordination of perjury and is punishable in the same manner as he or she would be if personally guilty of the perjury so procured. So it's the same penalty. It's not 50%. It's not 20%. You're going to get the same thing. So if you go get someone to lie on the stand for you or what have you in a case, and they get caught and they get prosecuted for perjury, or you get prosecuted for subordination of perjury, you're going to get the same thing. So hopefully that kind of makes a little bit of sense there. So Remember, the crime of subordination of perjury has those two essential elements, that one person willfully procures another or gets another to commit perjury, and that two, that such other person shall commit perjury. So there you have the subordination of perjury. Well, what about bribery? And what does that really even mean? And we hear that a lot. We hear bribery actually quite a bit. So the crime of bribery is unique in that it involves several individual laws. Common bribery includes elements like asking, giving, accepting, or offering anything of value or advantage or promise of the same. To or by the class of persons named in the bribery statutes, and there are a bunch of them in there, with the specific intent, and here we go with the intent thing. But remember, we talked about this before, some codes, they tell you the intent, which makes it kind of cool, with a specific intent to corruptly influence any act, decision, vote, opinion, or other official function or duty of such person. So the actual section, you know, again, bribery is kind of unique because it involves all of these different things. Well, mostly we hear this kind of thing with police, right? We hear that bribery section when it comes to like law enforcement. So there is a section for that. Bribing executive officers is what it's called, and it's Penal Code 67. Every person who gives or offers any bribe to an executive officer of the state with the intent to influence him or her in respect to any act, decision, vote, opinion, or other proceeding as such officer is punishable by imprisonment in the state prison and is disqualified from holding any office in the state. Now note the term executive officer here, as it's used here, includes police officer. So if you pull somebody over, they offer you $100 not to write them the ticket, that would really kind of fall underneath that bribery section. Now there's a lot of other sections there, and we're not going to go through them all, but remember, we're talking law, criminal law, and there's a section for everything. And sometimes they're very specific. So here you have members bribing members of the legislature, and you have Penal Code 85 and 86. Judges, jurors, or arbitrators, bribing a witness. City councils, board of supervisors, participants in sporting events. That's kind of interesting, right? So those, you know, bribing them to maybe throw the game or something like that. Solicitation. So all of these are other bribery statutes that kind of fall in there. And there's a lot of other like falsification crimes that we're going to get into in just a minute, and we're not going to go through all these. We may hit on a couple, but before we go there, I wanted to talk about one interesting thing, and I don't want to take a lot of time on it because I'm looking at the time right now, but there's a thing, and this is relatively interesting. So peace officers, so what about this thing called gratuities? You ever heard of a police officer taking something for free, like food or a gratuity or something like that? So I'm going to read you this section and let you kind of think on it as we go through, and we'll see how much time is left, and maybe we'll come back and talk about it. But so it's Penal Code 70, subsection A. Every executive or ministerial officer, employee, or appointee of the state of California, county or city therein, or political subdivision thereof, yes, it's a lot of legal stuff, who knowingly asks, receives, or agrees to receive any gratuity or reward or any promise thereof, accepting such as may be authorized by law for doing an official act, is guilty of a misdemeanor. So I don't want everybody to think, hey, you can't take like a cup of coffee or be offered a cup of coffee from a restaurant. That's not what this says. There's a little bit more to it. This really talks about accepting something on a promise or an official act. Okay, so if you say, I'm going to extra patrol your place for 14 donuts and a cup of coffee, that's the official act. If you're just going in and somebody gives you, you know, a cup of coffee, you have your own cup and they give you a cup of coffee, that's really, it's a gratuity, and it may be a violation of department policy. Okay, but it's not going to be a chargeable misdemeanor under unauthorized gratuities. But Penal Code 70, take a look at it, and it's kind of interesting. So here we have a list of other falsification crimes, and we're going to try to kind of finish this up because we're running out of time. And there's a lot of them. So when you look at it, there's offering false evidence or preparing false evidence or planting evidence or even destroying evidence. So any person who knowingly that any book, paper, record, instrument of writing, digital image, video, other matter or thing, etc., is about to be produced in evidence upon any trial, investigation, etc., willfully destroys or conceals it. It's a misdemeanor. So that's like a destruction of evidence. There's dissuading witnesses sections, or threatening witnesses or families, or threatening a crime witness. There's even sections like misusing the 911 line. Penal Code 653Y, any person who knowingly allows the use of or uses 911 telephone system for any reason other than because of an emergency is guilty of an infraction. So you can get fined for that. Well, how about falsely reporting a crime? Sure. Penal Code Section 148.5 says it's a misdemeanor to knowingly make a false report of a crime, or falsely report or false reporting of police misconduct. This is a great one, and then we'll kind of move on. So this is Penal Code Section 148.6, and this is what we do when people make false allegations regarding police officers. It is a misdemeanor to knowingly file a false accusation of official misconduct against any police officer. Any person filing a misconduct complaint is required to read inside the notice to this provision, and it talks about the Section 148.6a, and the California Supreme Court upheld this issue in People versus Stanistreet. So knowingly filing a false claim on a police officer could be a misdemeanor. So just a lot of interesting sections there on page 80 and 81, and even 82. It talks about identity theft and impersonating a police officer and providing like a false name to a police officer. Take the time to kind of read those because they're very, very interesting, and I think you'll learn a lot. So finally, let's finish up with conspiracy, because we want to kind of stay within our 60-minute guideline if we can. So conspiracy is Penal Code Section 182. May be defined as two or more persons agreeing to commit any crime where at least one of them does an overt act in furtherance of the conspiracy. Now, conspiracy is a county jail wobbler, again, meaning misdemeanor or felony, it just depends, even if the initial agreement is to commit a misdemeanor. Conspiracy is a specific intent crime, okay, and we've learned about general and specific intent. And the overt act that we're talking about is required and means any step which goes beyond mere participation. So kind of a quick review on that. Conspiracy defined as two or more persons agreeing to commit any crime where at least one of them does an overt act in furtherance of the conspiracy. The term overt act means any step taken or act committed which goes beyond mere planning or agreement to commit the crime. Now, the elements of Penal Code Section 182, and we'll talk about overt act a little bit more. Well, actually, we'll do it right now. Overt act means any step taken or act committed which goes beyond planning, agreement to commit the crime. So the elements of Penal Code 182 are on page 82 in your textbook, and it talks about if two or more persons conspire. So let's break it down. To commit any crime. Number two, falsely and maliciously to indict another for any crime, or procure another, get somebody, to be charged or arrested for any crime. Three, falsely to move or maintain any suit, action, or proceeding. Four, to cheat and defraud any person of any property by means which are in themselves criminal. Five, to commit any act injurious to the public health, public morals, or to pervert or obstruct justice or the due administration of the laws. And six, to commit any crime against the person of the president or vice president. And there are some other things that go underneath that. Now, remember, conspiracy is a specific intent crime, requiring the accused to have the intent to commit the offense, which is the object of the conspiracy. Now, to sustain a conviction for conspiracy, there must be proof that the accused entered into a criminal agreement with specific intent to commit an unlawful act or to do a lawful act in an unlawful manner. And we've already talked about what that overt act would be in conspiracy. So again, you need to have an agreement. to commit a crime as an element of conspiracy. It may be inferred from the conduct of the defendants in mutually carrying out a common person in violation of the statute defining conspiracy. And then a change. Okay, one last thing as we finish up here, an interesting change. Husband and wife can conspire between themselves without a third party and can no longer claim immunity from prosecution for conspiracy based on their marital status. This wasn't like this before. So this is new. This has changed. Before, they could always claim that there was a husband-wife relationship and claim immunity from that. Well, now the husband and wife can conspire between themselves without a third party and can no longer claim immunity from prosecution for conspiracy on the basis of their marital status. And just kind of like theft or attempt, as we looked before, I think it was attempt, we talked about abandonment. So a couple of things that really you have to have for that. Must withdraw from all further activity, must remain away from the scene at the time to the crime is committed, must make intent to withdraw known to your counterparts, meaning like, hey, I don't want to do this crime anymore, I'm out of here. Must indicate a desire to sever the relationship to the illegal enterprise or the group of people that are actually going to do that target crime. And there's a couple of cases there that go with it. But if you want to abandon conspiracy, you don't want to get charged with the attempt or the actual conspiracy itself, these are the elements that need to take place. And quickly, criminal liability and conspiracy. All conspirators are liable for the consequences that naturally flow from the conspiracy and for the acts of all who participate. Co-conspirators need not join in the agreement all at the same time, and a member of a criminal street gang who promotes, furthers, assists, or benefits from any felonious criminal conduct by a gang member is guilty of conspiracy to commit that felony. So I know there was a lot of information there, but thanks for hanging with me, and that'll be the end of chapter 6. And if you have any questions, please post them on the discussion board, and I'd be more than happy to get back with you or someone else in the class who will help me by answering the question. So that's it for today. Until next time.